Well, good evening. Hello, hello. It's nice to see you all here. A few folks are filtering in. It's lovely to have you. My name is Claire Bishop, and as Executive Director of American Public Square, it is my privilege to welcome you to tonight's program. In just a moment, we will be hearing from an illuminating and venerable voice on the topic of free speech, Ms. Nadine Strossen. Nadine will be in conversation with Lacey Griffin, the Collection Development Manager for Johnson County Library. But before we get to this great show, I've just got a couple of very few remarks to make. First, thank you so much to our partners in this event, the Johnson County Library and the Johnson County Museum. I'm pleased to share that after the seated dialogue tonight, you are invited to join us for a reception downstairs, and we'll make sure to show you how to get there if you don't know already, because this place is kind of big. And downstairs in the reception, Nadine will actually be joining us to sign copies of her book and join us in conversation. So please plan to stay to enjoy refreshments and post-event discussions if you're able to. And as well, you'll be able to enjoy a chance to see Johnson County Museum's special exhibit, Everyday Democracy, Life, Liberty, and the Pursuit of Happiness in Johnson County. I should say that this is normally a ticketed exhibit, but because of this special partnership, you'll be able to enjoy it at no cost tonight. So that's exciting. I also want to share that you all are receiving a free copy of War on Words, the book that Ms. Strossen will be talking about this evening. And that's thanks to the generous work of the Johnson County Library. So those are going to be available downstairs. You do have to go down there to get your book, and that was on purpose. The library invites you to sign up for a library card for access to all of their materials, ranging from books to streaming services. Anyone is eligible for a card. I don't think you need to live in Johnson County, so anyone is eligible. And Johnson County residents are also eligible for online-only cards. Library cards are fine-free to ensure access within the community. Thank you all, everyone in this room and everyone joining us live stream, for joining us for tonight's event. And I want to make a special thank you to our APS members, as well as members and supporters of the Johnson County Museum and the Johnson County Library. Your engagement and support makes programs like this possible for our community, and we are truly appreciative. I want to share that tonight's program kicks off a summer of events tied to the 250th anniversary of the founding of our country. APS is planning a summer of opportunities to explore our shared history, assess our current state, and look forward together. I'm especially excited to share that on June 18th, Nadine Strossen will be back in Kansas City moderating a panel discussion, Self-Evident Truths, Grading the Declaration of Independence's Legacy at 250. This event will be held at Yardley Hall at Johnson County Community College. It features an absolutely stellar panel, including historian and author Akil Abar, Dr. Lindsay Chervinsky of the George Washington Presidential Library, and Yuval Levine of the American Enterprise Institute. These folks will be grading how we live up to our ideals 250 years later. That's going to be an exceptional program. Tickets are free, and more information is available on our website, americanpublicsquare.org. So please go there to learn more about that and sign up. We'll look forward to seeing you there. Okay, so it is time to move on to the program. I told you my remarks would be brief. I'm about to step off this podium and hand it over to these ladies here. But quickly before I do, I just want to let you know, Yvette Walker from the Kansas City Star at this table back here is our roving reporter tonight. So we have a certain way that we do questions in the audience. We encourage you to ask questions of our panel, and we do that with these, the question cards. So if you don't have one and you want to ask a question, raise your hand. Someone will bring you around a card. Write down your question, hold it back up, and someone in a black APS t-shirt will come around to collect it. They'll hand them off to Yvette, who will curate them while she's listening with one ear to the conversation, and she'll be doing her best to ask as many of your audience questions as she can. And I should mention, if you're tuning in on the live stream tonight, you can also submit your questions via the chat feature. Alan Rostron of the UMKC Law School is our live fact checker for the night, and you can use the same method as you would to submit a question to submit a fact check. In fact, these cards, they've got questions on one side and fact check on the other, so they're dual purpose. So you can submit this for both. So with that, it's my distinct pleasure to hand it over to Lacey to get our conversation underway for the evening. Thank you all so much.
Thank you. All right, good evening, everybody. Is so glad this is such a great full house. We're in for a treat tonight. My name is Lacey Griffin. I work for the Johnson County Library, and I am here with Nadine Strossen. This bio is awesome, by the way. Is one of the country's leading voices on free speech and civil liberties. She served 18 years as president of the ACLU, becoming the first woman to run the organization. She is an emerite law professor for the New York Law School and is a senior fellow at FIRE, the Foundation for Individual Rights and Expression. Strossen is the author of several influential books about free speech. In 2023, the National Coalition Against Censorship presented her with its Judy Blume Lifetime Achievement Award for Free Speech. Welcome. Thank you for coming tonight.
Thank you so much, Lacey, for that gracious introduction, and I'm really honored to share the podium with you because you have been an award-winning champion of intellectual freedom here, where it is very embattled. And I'm just absolutely thrilled at the turnout. Freedom of speech depends upon knowledge and concern, and the mere fact that you have taken your precious time to be here on such a beautiful day makes me feel very confident about the future of free speech in this beautiful part of the country.
Oh, thank you. Thank you so much. All right. So tonight I want to start from the beginning. Tell us a little bit about yourself and how you got into this line of work. Did you know early on, or was there this defining moment that was a catalyst?
From as far back as I can remember, Lacey, I had an instinctive sense about my right to express myself and an instinctive chafing against those who sought to restrict what I was trying to say, including my parents and my teachers. And as I mentioned yesterday when we were at the library, a formative experience for me was suppression of access to ideas when I was under 18. I grew up in Hopkins, Minnesota, so the same general part of the country. I always love coming back to the heartland. But one negative thing about the Hopkins Public Library, which I was dependent on because my parents were not wealthy, but I'm so grateful that they always nurtured a love of reading and encouraged us to use the public library. The public library system there had not subscribed to what I later learned is the American Library Association's Bill of Rights, which had been adopted quite a bit earlier, and guarantees freedom of access to all library resources for everybody, regardless of who you are, regardless of any demographic factor about you, including age. But that was not honored in my public library. So until I reached the age of 18, I was restricted to reading only the books that were in 2 rooms. At the time, the term that was used for a person like me was a bookworm, and I had wormed my way through all of the books in those 2 rooms very early on. Then to add insult to injury, one of my favorite series of books was the Nancy Drew Mysteries. Do we have any other? And the Nancy Drew Mysteries were withdrawn from the school library. And I did a little bit of research and learned that that happened in many, many public libraries. And the reason that the book was controversial and targeted was exactly the reason why I found it so appealing, that she was a girl who was independent, and she didn't necessarily listen to either her father or her boyfriend. And worse yet, she bossed around her boyfriend. Remember Ned? And so that that was considered to be very, very dangerous. And so, you know, I'm fond of quipping that there's this kind of a double-edged sword, because having these various restrictions on my freedom of access to information and ideas and to self-expression no doubt helped turn me into a civil liberties activist. So maybe the prescription for turning out future civil libertarians is to squelch their freedoms. When I found out at an older age that there actually is a constitutional right and other legal protections, and that there are organizations, including the American Library Association, including groups like the ones APS and the others that are wonderfully co-sponsoring this event, that are actually working to turn those legal goals into reality, because no law is self-enforcing. I happily threw myself into the organizations and into advocacy. I'd like to add one more recent perspective here, Lacey, because for most of my career with the ACLU, I have fully and firmly, enthusiastically advocated the ACLU's entire agenda, which I continue to enthusiastically support, and that is defending all fundamental freedoms for all people, no matter who you are, no matter what you believe. By virtue of your humanity, you are entitled to certain basic human rights, and I enthusiastically defend them all from A to Z. However, starting about a dozen years ago, I started to see such a tide of illiberalism from both ends of the political spectrum, attacking the classical Enlightenment values of freedom of speech, freedom of thought, academic freedom, that I decided that I would use my remaining time on this earth to focus completely on that cluster of rights. Not because they're more important than privacy or due process or equality or any of the other fundamental human rights, but rather because those freedoms of thought and expression and advocacy are absolutely essential for advocating and protecting all of the other rights. Throughout history, these First Amendment rights have been the way to promote the rest of the human rights agenda, and for that matter, any other cause that you might advocate, whether it be, on government policy or on climate change, et cetera, et cetera. And conversely, throughout history and continuing till today, the major tool to repress all other rights has been censorship.
Thank you. Oh man, so much in that, so much. So as we were talking about First Amendment rights and censorship, one of the things we talked about yesterday is that there have been certain court cases, things that have come up in the media and things lately that have been really challenging what the First Amendment right is. Can we talk about what is the law of the land right now, what is protected in the First Amendment, and then what kind of things right now are trying to challenge that?
So those of us who teach in law schools, such as Alan, who is graciously being our fact checker back there, can attest that we spend an entire semester-long course in law school to answer that question, Lacey. But
you've got like 10 minutes.
I recently wrote a book before this one that actually does try to summarize all of free speech law. And the more I learned about it and thought about it, the more I realized that for all of its marvelous complexities, it really can be boiled down to two fundamental basic principles that make a great deal of common sense. And the first of these principles is what the Supreme Court has called the bedrock principle underlying our freedom of speech. And the term for it is viewpoint neutrality. Sometimes it's called content neutrality. And what that means is that the government must remain neutral with respect to the view, the content, the message, the idea of the speech, no matter how controversial that viewpoint might be, no matter how offensive, no matter how hated or hateful. Disapproval of the idea, the content, the message is never a justification for government restriction. If you dislike the idea or disagree with it or hate it, use your own freedom of speech to speak out against it, but don't empower the government to pick and choose which ideas may be circulated and which may not. The complementary second principle is often called the emergency principle. And what that means is if you get beyond the idea, the view, the message, and consider the expression in its overall context, if in the particular facts and circumstances the idea directly causes or imminently threatens certain specific serious harm, then it can and may be restricted. And the Supreme Court has recognized several categories of expression that either directly cause or imminently threaten certain specific serious harm, posing an emergency, and therefore justifying repression. So one example, and it's relevant to a recent indictment of former FBI Director James Comey. Some of you may have read about that because of seashells that spelled out a number. And the number connotes to some people, I had not known this, I was ignorant, but some people realized that it stands for calling for some kind of negative action against the person who is referred to. That cannot be punished unless the argument is, or the allegation is, that that was threatening the assassination of the president. The Supreme Court has rightly recognized that the general way we use the term threatening, I feel threatened by seeing that message or hearing that speaker, is not enough of a justification to restrict speech. But the court has used the term true threat to refer to a subset of threatening speech that does satisfy the emergency test. Basically, if the expression is directly aimed at a particular person, so posting something on social media is not going to count, and it intentionally or recklessly instills a reasonable fear on the part of the targeted person that they are going to be subject to an attack. That is a punishable true threat. You can ask yourselves whether the Comey situation satisfies that standard. The overwhelming consensus is that it does not. And the reason for drawing that distinction is that it is really important to be able to express strong criticism of political leaders. That is important not only for individual liberty, but also for our democratic republic, where we, the people, wield sovereign power. And how can we do that effectively unless we can, even strongly and harshly and even unfairly, criticize our political leaders? But when it crosses the line and becomes a true threat, it can and should be punished. I have to make one other point, Lacey, and I think it's pretty good for, a semester's worth of material.
I think you did great.
Under 10 minutes. There's one, in addition to speech that satisfies the emergency principle and therefore is a viewpoint neutral restriction, because the speech is not being punished just because of objection to its viewpoint, but rather because of the imminent danger that it poses. There's a second major category of viewpoint neutral restrictions that are constitutionally permissible, and those are referred to as content neutral, time, place, and manner restrictions. So the government can fairly say in a certain place, let's say a government building where, let's say a post office, which exists for purposes of carrying out a certain function, the government may say this is not an appropriate place for people to express their views about other issues. This is a place for conducting business. Or in a university campus, to use another important example. If you're talking about the main quad, a gathering area in the middle of campus, students and faculty members and others should be free to express their views the way they would in a public park on any issue of public controversy. But not in a classroom, not in a laboratory, not in a library, which is set aside for other educational purposes.
Yeah. You have talked about both sides of the political spectrum kind of abandoning support for free speech. What do you mean by that?
Well, Lacey, I actually I'm not going to fault you for this, but, because we use this phraseology, both sides, and in some ways that's completely antithetical to, I know what your values are as a librarian, and certainly American Public Square and the other sponsoring institutions, that, we are not just divided into binary tribes on issues. We're concerned with ideas and policies, and we have a range of ideas and perspectives. So let me somewhat rephrase it, because I think that's such an important point. I think that the extent to which our society is polarized and divided is, fortunately, I think, exaggerated, according to very sophisticated polling that's done by a number of organizations I really respect, including one that is based at Dartmouth College but involves a consortium of multiple universities and colleges called More in Common, which does repeated surveys that show that the vast majority of us are clustered somewhere around the middle, middle right, middle left, and are hungering to discuss ideas, controversial issues with people who have differing perspectives, are hungering for government officials and politicians to do the same. And for various reasons, the media tends to give undue or disproportionate emphasis to about 8% on either end of the political spectrum. So that aside, let me talk about the extremes of the political spectrum and everything in between. It is fair to say, and many observers have commented, that the vast majority of people believe in freedom of speech for me, but not for thee. And, everybody seems, I have debated every advocate of every serious restriction on free speech, including your native son, from Missouri, John Ashcroft when he was Attorney General, and Ed Meese when he was Attorney General, and many, many others. And every single one of them says, I support free speech. And you know what the next word is, right? But, exactly. And everybody has a different but. I spoke with somebody else from another free speech organization recently, and he said that their organization was working to have the narrowest butts possible. So some of you may remember, show of hands, does the name Skokie mean anything to you? The Skokie case? Let me just say a little bit about that, because it really captures both what the free speech principles are and why everybody pays lip service but then makes exceptions. So the Skokie case was a case in 1977 to 78 arising in Skokie, Illinois, which is a town, essentially a suburb of Chicago, that not only had a very large Jewish population, but at the time, a very high percentage of the Skokie residents were Holocaust survivors. And for that reason, a group of neo-Nazis wanted to demonstrate in Skokie, right? In order to get the attention of the media and be provocative. The same reason why people who oppose abortion want to demonstrate in favor of Planned Parenthood and so forth. They came to the organization of which I was president for many years, the American Civil Liberties Union, to represent their right to free speech, including hateful speech. The only argument that was being made against their peaceful, non-disruptive demonstration was abhorrence of the ideas, which I certainly share, as did my ACLU colleagues. But as you know, under the First Amendment, that is not a justification for restricting the speech. So the ACLU easily won that case in the courts of law. It went all the way up to the Supreme Court, where the Supreme Court did something very unusual. It upheld the First Amendment rights of the neo-Nazis without even receiving briefs or oral arguments. It was a slam dunk winner in the courts of law. But in the court of public opinion, that was extremely controversial. And the ACLU, this organization of people who are dedicated to robust free speech, we lost 15% of our members. People who said, I really believe in free speech, but. And, you know, my friend at the time, a wonderful woman named Leanne Katz, was the executive director of the National Coalition Against Censorship. And she said, you know, Nadine, everybody has his or her Skokie. And it's really true. If you add up all of that, just one exception that people want to make, there's really nothing left. And the one group of people who really do not fall into that common pattern of wanting to make just one exception for the idea that they consider the most dangerous idea under the sun. The one major exception are the judges, including justices on the United States Supreme Court. Even the current court, which by my standards has backslid on a number of important human rights and constitutional rights, has continued to, by very lopsided margins, often 9-0, despite all of the strong differences on other issues, continue to uphold freedom for very controversial speech that many members of the public want to censor. And I ask myself, why the difference between the justices and the public? And the answer is clearly that the justices are familiar with what the First Amendment principles are and familiar with the history that gave rise to them, the terrible experiences that we had of government censorship before those principles were established. And that's why I believe that the more information people have about the history and the current scope of free speech, the more supportive they will become.
We have some questions from the audience. This is our wonderful Yvette Walker from the Casey Star. What do we have? Oh,
All right.
Star
Do I need
from
to
the
turn
Star.
this on? Here we go. I do. We have some questions for you, Nadine. Could you please speak to the current climate on university campuses? I'm a professor. When I was in school, it was okay to have differing opinions. You strengthened your arguments that way. Now it seems doing so can get you fired. It's not okay to go against the grain. What can we do? We feel targeted.
This is such a serious issue, and one of the reasons that propelled me back about a dozen years ago when I started seeing the inroads on free speech, not only in society in general, but in particular on university campuses where one would expect freedom of speech and freedom of inquiry and robust debate to be at its strongest. Survey after survey after survey shows that all of us on campus, again, all across the ideological spectrum, are engaging in enormous self-censorship. Faculty members as well as students. The organization with which I'm a senior fellow, FIRE, has been doing the most extensive surveys working with College Pulse, and they show that substantial pluralities of students say that they cannot have a free and frank conversation on their campus about a host of the most important issues, including abortion, immigration, police practices, anything to do with race and gender, certainly anything to do with Israel-Palestine, that they dare not even address the topic at all, let alone raise certain perspectives that they consider to be unpopular. Now, until recently, I could say that the cause of self-censorship was not fear of government punishment. It was fear of your peers, in particular, fear of students. Tragically, within the last year, under the second Trump administration, as you know, if you are a non-citizen on campus, among other places, you do have reason to fear the government. If you engage in expression that is critical of certain administration policies, you reasonably fear being arrested and detained and deported. But for the rest of us who are fortunate to be American citizens, we have, unfortunately, reason to fear the shaming and shunning and ostracizing of our peers. That is a cultural issue. There's no legal solution to it. And it is rather difficult to change the culture on campus. It can't be done by older folks such as us professors. It has to be done from the ground up. You know, professors and administrators can serve as mentors and as role models, but the students themselves have to change their own culture. And I'm happy to report that organically on campuses around the country, many, many student groups are springing up. One is called Bridge USA, Heterodox Academy is another, where students are taking the lead in trying to encourage the robust debate that is especially important and the candid discussions that are especially important on campus.
Now, are you ready for a little comment, critique about a former organization of yours? All right. You mentioned that about a decade ago, you started to notice illiberalism on both sides of the political spectrum. Some have argued that since the mid-2010s, your old organization, the ACLU, has been a part of this trend. Do you agree with this criticism?
No, I don't, but I really respect it, and I take it very seriously. So I am on the National Advisory Council of the ACLU, and I'm very close contact. In fact, I just was emailing today with the National Executive Director, Anthony Romero, who spoke here very recently, and he sends greetings to this wonderful part of the country. Please believe me, with my firm devotion to freedom of speech, if I believed that the ACLU was abandoning its traditional defense, I would be the first person to criticize it. Let me give you some important counterexamples that aren't known as well as they should be. Most recently, less than 2 years ago, the ACLU in the United States Supreme Court represented the National Rifle Association, the NRA, hardly a progressive organization. And you better believe that the ACLU was a little bit like the Skokie case. We got a tremendous amount of complaint, even from card-carrying members of the ACLU. In fact, the ACLU has what we call affiliates, state-based. We have one in Kansas, one in Missouri. And the New York affiliate, from which the case arose, disaffiliated itself from the ACLU for purposes of this case. The New Mexico affiliate did the same thing. And yet the national organization did the right thing, stood up for a very important First Amendment principle that in that case redounded to the benefit of the NRA, but is now the major precedent that is being relied on by Harvard, Columbia, National Public Radio, Corporation for Public Broadcasting, law firms, all of the entities that the Trump administration, and broadcast media, social media, all of the entities that the Trump administration is trying to defund or retaliate against for expressing ideas that they disagree with. So let me just, that's one example. Another example that really, like exactly 40 years later, tracks the Skokie case in Charlottesville in 2017. Remember that horrible Unite the Right rally? I mean, horrible because it devolved into violence. But there was no evidence in advance that violence was going to take place. In fact, when the city council tried to withdraw the parade permit, the demonstration permit that had been granted to Unite the Right, the police commissioner in Charlotte testified that there's no evidence of any violence and we've got it under control. So if there is violence, there will be no harm to public safety. And the only reason that was given for withdrawing the permit was the abhorrent viewpoints of the white supremacist organizations. The ACLU defended successfully the First Amendment free speech rights of Unite the Right. So let me tell you, and again, the principle will redound to entities and speakers with diametrically opposite perspectives. The Supreme Court case is a more important one, so let me just say a word about that. It arose from New York State under the administration of then Democratic Governor Andrew Cuomo. The person in his administration, Maria Vullo, who was in charge of financial regulation, threatened the banking industry and the insurance industry in New York State that she would subject them to regulatory sanctions, penalties, if they did business with the NRA. Well, if you don't have access to banking services or insurance services, you are out of business and you cannot advocate for Second Amendment rights or their view of what Second Amendment rights are. And as I said, many ACLU members said, hallelujah, we don't want the NRA to be advocating its view of Second Amendment rights. But as we pointed out, if the Cuomo administration could silence the NRA's advocacy in New York, the DeSantis administration could silence Planned Parenthood or the ACLU's advocacy in Florida. And we won that case 9-0 in the US Supreme Court. And that is the major precedent that is now being used to oppose the Trump administration's attempt to silence all kinds of institutions, including universities, and by the way, including libraries and museums, from expressing views that it disagrees with. So, and I could give some other local examples. I don't want to go on and on, but we talked yesterday about the attacks on public and school libraries all over the country. And I'm very happy but not surprised to see that the ACLU affiliates in Missouri and Kansas and Arkansas and Iowa, Texas, Florida, you name it, is the organization that's been representing the library associations and the school library associations. So the work goes on.
We have a question about the desire in our current administration of changing text on historical markers when they are factual. That seems like suppressing or blocking free speech. Can you speak to that?
Yes. It is not violative of the First Amendment according to the current Supreme Court. And I have to say, I think mostly correctly. Under a doctrine called the government speech doctrine, when the government is itself engaging in speech, purveying a certain message, advocating a certain policy, the government officials have the power and the right to choose what messages they will endorse and which they will oppose. It's different if the government tries to stop private sector speakers from voicing a certain message. And the Supreme Court has said, if you don't like the way the government is using its own expressive microphone, including by, changing historical markers, your remedy is not to bring a lawsuit under the First Amendment. Your remedy is to vote them out of office and vote in somebody who's going to replace the markers and, restore the messages that you think are appropriate.
From a fact-checking perspective, I have kind of an easy night here. Nadine is doing a great job, of course, of sticking to things that she knows a lot about and that are true, and Lacey as well. But I got to do something to justify my role. So I was curious to see, has Nancy Drew really had problems? Have the Nancy Drew books really? And that's important. They, in fact, haven't. I wasn't aware of this. They've been widely excluded from libraries it said from the 1930s to the 1960s. Not so much like the kind of, we might think of as like book banning and somebody's protesting and they don't like the books, more coming from librarians and teachers. To some extent, they felt like Nancy Drew wasn't acting properly for a girl. She was too bold and independent, but also that they felt that this kind of literature series of books is too formulaic and low-quality literature, would hinder reading development and draw children down a dark path to where they don't discover better literature because they like Nancy Drew too much. This isn't really a fact check, but Nadine talked a little bit about the true threat doctrine, and I would just add the case about James Comey. One of the important cases about that by the Supreme Court was called Watts versus United States back during the Vietnam War era. It's about a guy who got up at a Vietnam War protest and was talking about being drafted and how he didn't want to serve. And he said, if they ever make me carry a rifle, the first person I'll get in my sights is LBJ. And he kind of made a gesture like he was holding a rifle. And the Supreme Court concluded that this was just political hyperbole, rhetoric. It was a way of just saying you don't like the war, you don't like the president. It wasn't really a true threat. And it's, at least this is just my opinion, but it would be hard to establish that some seashells that say 8647 are a real threat if actually making a statement about the president and having a rifle and that sort of thing is not. Final thing I wanted to look at is there was some discussion about both sides being sometimes at fault for wanting to restrict speech. So I was trying to see what people of the different political parties have to say about these issues. The main thing I find is just further confirmation that we are very politically divided as a nation. If you ask people if they care about free speech, everybody says that they do. If you ask if we've gone too far in restricting speech, their answer most people will say yes, but the variation will depend on which party is in power in Washington. Right now, more Democrats would say they're concerned about restrictions on freedom of speech, but in a previous administration, if Joe Biden, for example, it would have been a little bit the opposite way. And the one thing that is really sort of sad is that when you ask people who they trust when it comes to freedom of speech, they generally trust their own party and not the other party at all. And independents, they don't trust either party, so...
Thank you, Alan.
That was great, Alan. Thank you so much.
Nadine, think what we could have been if we hadn't read Nancy Drew. We were held back. That cracks me up because those are the same reasons that often Junie B. Jones and Captain Underpants get the same. That's the exact same worded that usually comes when those get challenged too. So.
Oh, may I ask a follow-up fact-checking question for Alan? I just, as a feminist, my antenna make me wonder whether, like the Hardy Boys and whether Boys series were also challenged as being too formulaic.
Interesting. I really want to know that too, Alan. All right. This is a person I did not know about until I had spoke with Nadine, and we've talked about. Nadine, who is J.S. Mills?
Oh, thank you so much for asking that question. This gives me, when I saw Lacey sent me some questions that she was proposing to ask me in advance, and I said, thank you for that question because I can use my favorite prop. So here it comes. Get very, very excited. What do you think this is? Okay. Lacey, what does it say?
Make J.S. Mill great again.
So my Republican friends get very excited and then they get very disappointed when they see that. And my Democratic friends get very nervous and then they get relieved. So how many of you know who John Stuart Mill was? Don't be embarrassed. Okay. I'm so happy to get to then introduce him to the rest of you because in 1859 he wrote, and there's going to be a footnote, I'm a law professor so I love footnotes, but for now he wrote a classic essay called On Liberty, which remains, in my view and that of many First Amendment advocates, the classic, most powerful, persuasive defense of robust freedom of speech, including the viewpoint neutrality principle. Here's the footnote. This is considered like one of the most influential works of political philosophy that has ever been written. And there is a lot of evidence and growing historical consensus that it was actually co-authored with his wife, Harriet Taylor. Thanks to algorithms and other fancy exploratory tools that we have available now for investigating language, scholars have purported to demonstrate that there are language patterns that are among other reasons why they think she should be credited as a co-author. I was really thrilled to get this as a gift from a human rights organization in the former Czech Republic. I was just like drooling over it, and finally they gave it to me. They had commissioned it. As with many other countries I've visited where they have recent experience with direct, explicit oppression, they tend to be much more supportive of free speech than in this country. We tend to take it for granted. And you know, one of the silver linings, the cloud of the increased restrictions lately is I think more people have become more concerned about free speech. So Mill basically said, he made two really fundamental points. One is, many people are surprised to learn this, who know that he was writing about free speech. I'll say he and Taylor say at the beginning, the major threat to free speech is not the government. The major threat is social pressure. The peer pressure, the fear of society heaping contempt upon you. So many of us think that this phenomenon of so-called cancel culture is something new. No, it's always been with us. Even in 19th century Britain, when the government certainly had and exercised more restrictive power than the US government does now, still, for libertarians, civil libertarians such as Mill, the major impediment to candid and frank discussion was society. So that's one really important point. But they then went on to say, look, you know, every single idea deserves to be heard, because logically it can fit into only 3 categories, and all 3 categories are worthy of hearing the speech. Number 1, the idea may turn out to be completely false, in which case your idea may turn out to be completely false, in which case it's really important to have it out there, subject to challenge, subject to debate, so you can realize that it's false and instead adopt a true idea. Number 2, your idea may turn out to be partly true, partly false, and so by having it debated in the marketplace of ideas, you come to understand that it's not quite right, and you can refine it and make it more accurate. The third possibility is your idea, it's subject to debate out there in the marketplace of ideas, and you're not persuaded that it's flawed in any way, so you reaffirm your pre-existing understanding, but you then do so with a deepened understanding of it. You're not just repeating the same idea as dead dogma. That was the phrase that they used. But you can defend it and explain it in a more powerful and persuasive way.
Love that. Why? So, as we've been talking about censorship and about the First Amendment today, why do you think we keep doing, it seems to cycle throughout history? We've just talked about J.S. Mills, we talked about different times throughout the history of the world that we've had it, and it just seems to be like this cycle that keeps rotating. Why do you think we keep in that cycle, and why do you think we're not learning from the past?
Because, and I'm going to quote my co-author, Greg Lukianoff, who is the CEO of FIRE, he uses the phrase, the eternally radical idea, to describe what Mill and Taylor talked about, the viewpoint neutrality principle. It is so counterintuitive to allow freedom for the thought that you hate, that you believe is evil, that you believe is wrong, that you believe is potentially dangerous. Even if it doesn't satisfy the emergency principle, it still may be very harmful. So I think it is a natural human tendency to say, that's an evil idea, it has no place in the marketplace of ideas. And it's harder to explain. I mean, it takes at least a few minutes, if not an entire semester, to explain why actually there is harm in suppressing even potentially dangerous ideas. And it's a lesson that has to be learned over and over and over again, not only for each person who is newly encountering these concepts, but for those of us who have been working at it forever. We have to, and we should constantly re-examine and revisit. The defense of free speech, Mill would be the first to say, Mill and Taylor, and I agree, that we have to keep justifying why the harm of, and let me say, I'll interrupt myself and say, yes, free speech can be very harmful and very dangerous, but that does not justify censorship, because censorship can be even more harmful and more dangerous. And I reread, in preparation for our conversation yesterday, the American Library Association Bill of Rights, and they have a wonderful line that goes back to 1939. I'll try to paraphrase it. You may know it better than I do, Whit Lacey. And it's, ideas may be dangerous, but censorship is the greater danger.
Excellent. Do you see anywhere as a country where we have made some progress? Is there anywhere where you see, give some examples? Enormous
progress. And that's, I think, when I look at, even within my now long, thank goodness, lifetime, enormous progress, and certainly over the course of American history, going back to the Declaration, let me just start by saying, although the First Amendment was adopted in 1791, as you all know, for most of its history, it was a dead letter. It had no real meaning because along with the rest of the Constitution, the First Amendment is not self-enforcing. It is not self-executing. Government officials can get away with violating constitutional rights, and they often do, unless or until somebody stands up for those rights and goes to court to get a court to enforce the rights. And courts can't just reach out and say, oh, that statute is unconstitutional, or that action by that police officer in punishing a peaceful protester is unconstitutional. No, they need a court case because of a technical doctrine called standing. And so this is why the ACLU was founded more than 100 years ago to try to put real meaning into the First Amendment and other rights, and why the NAACP was founded, because the Equal Protection Clause had existed since the Reconstruction era, and we know that was not enough to stop Jim Crow and all kinds of racial segregation and discrimination until the civil rights movement brought cases that got the Supreme Court to actually enforce the First Amendment. So, in fact, the 14th Amendment, and I use the two interchangeably because, in fact, it was in the specific context of the civil rights movement of the 1960s and 50s that the Supreme Court started to robustly enforce not only the Equal Protection Clause, but also the First Amendment, because censorship was the major tool that was used to try to chill and curb and halt the civil rights movement. Most people know that Martin Luther King wrote his historic, eloquent letter from a Birmingham jail. Most people don't know what he was in jail for. What was the crime that resulted in his imprisonment? It was what we now consider to be the most fundamental exercise of First Amendment rights of speech and association and the right of the people peaceably to assemble and to petition their government for redress of grievances, and for that matter, free exercise of religion, because King had a religious motivation. So all 6 of the First Amendment freedoms, but they were honored in the breach. There weren't Supreme Court decisions that had actually upheld those rights until the 1960s. So that's an enormous milestone. And I would say starting in the past several decades, the Supreme Court really has made very strong strides toward very strictly enforcing the viewpoint neutrality principle. Again, really across the ideological spectrum. So there are some setbacks, but on the whole, we have vastly more free speech rights now, certainly than our parents and grandparents did.
Thank you. All right, Yvette has some more questions from the audience.
Some very challenging questions. All right. Does the use of AI to create, summarize, or amplify speech change the legal responsibility of the speaker? What are the overall implications?
I think that this is being debated right now, and there are serious legal scholars who argue that somehow AI, and more importantly, there was actually one court ruling that said AI should have no constitutional protection at all. I think that is a minority perspective, and it's the weight of authority and of judicial rulings to date is that it should be treated the same as any other technology or tool, whether it be a typewriter or a computer or a camera, et cetera, I love the phrasing of that question, Yvette, to amplify, disseminate, distribute a message that a human being is conveying. Those who subscribe to a relatively narrow, conservative approach to constitutional interpretation, I'm sure you've heard the term originalism or textualism. And that's predominant philosophy on the current Supreme Court with its 6-3 conservative majority, that they will strictly construe the terms of the First Amendment, which the relevant terms are Congress shall make no law abridging the freedom of speech or of the press. And then they also look at what was the original understanding of those words at the time they were adopted. And I think the consensus of historians and scholars is that press was added because that was the only technology that existed for disseminating expression at the time, right? So speech is what you actually do with your own voice. But if you are using the then available technology, the press, that is also protected. And the Supreme Court has extended that logic through every technological innovation since then, with one hiccup. It took a while before it recognized that films constitute a protected technology under the First Amendment, but it had no hesitation in doing that with radio and telegraph and TV, the internet, social media, and I think AI should follow.
And then we had several questions on the intent of the speaker, sincerity versus propaganda and lies. I'll just read one. What steps can be taken to balance freedom of speech with the increased willingness to lie? And then I'm going to add on to that, and what about elected officials? Do they have a First Amendment right to lie?
Yes. Yes. And, I'm not sure that it's increased. Every time I go back and look at some of the terrible, in the sense of harsh and false propaganda that was slung about in the earliest historical era, the the Federalists versus the Republicans, and Jefferson versus Adams. And if you go back and look at some of the political propaganda, it seems to me completely comparable to what exists today. The Supreme Court has said fairly recently that you basically have a right to lie, except, and we're going to go back to this emergency concept, if in the particular context, and a point that Yvette or the questioner made with a certain intent, the lie directly causes certain specific harm. And there are several kinds of lies that satisfy that standard. One is defamation, when you intentionally say something that you know is false and harms the reputation, leading to economic suffering on the part of the person who is defamed. Another example is perjury in a court of law, where you're subverting the rule of law and due process of law. Another example is fraud, where you intentionally get somebody to rely on a false statement to their financial detriment. But when you get beyond that to the kinds of political rhetoric and hyperbole that usually, invariably would involve matters of interpretation and analysis and opinion and perspective, we don't want the government to be deciding which of those misleading statements should be punished, because that creates the danger of punishing disfavored viewpoints or disfavored speakers. And the way the Supreme Court put it in this fairly recent case was, we don't need Orwell's ministry of truth here. And let me throw in one other historical perspective, and goes back to the civil rights movement and MLK, which I referenced earlier. the Alabama and other southern states at a time before the Supreme Court had protected against defamation lawsuits against public officials. This is the question about government officials. The states deliberately used a strict liability approach to defamation. Any false statement that was made about any government official, no matter how trivial, could lead to enormous damages, penalties of huge amounts of money that would be essentially disabling for civil rights organizations or for the national media that were covering the civil rights movement. Some of you may have heard of the famous case of New York Times versus Sullivan, in which the Supreme Court reined in defamation liability. And I think what many people don't realize is that particular lawsuit was part of a systemic campaign that the southern states were waging in a deliberate effort to silence both the civil rights demonstrators themselves and the national media that was giving traction to their movement. So yes, disinformation, misleading or false statements can be harmful, but again, we have to weigh against that the harm of empowering the government to make judgments and to punish on that basis.
I've done my best to get to the bottom of the crucial issue of which faced more censorship, Nancy Drew or the Hardy Boys, and I'm not really sure. Both have been subject of a lot of criticism, maybe in some ways, maybe more so for the Hardy Boys, but in terms of their literary merit, they seem to be judged about equally poorly by a lot of people. And the Hardy Boys has apparently faced more criticism in more recent years for some of the early books, I guess, according to sources, had a lot of casual racism and perpetuation of derogatory stereotypes. They were just written a long time ago, and so some of the books were either pulled or rewritten because of some of the content. And that didn't seem to be as much of a problem for Nancy Drew. People seemed to regard her books as more wholesome. She was kind of the girl next door, and there was less offensive stereotyping and that sort of thing. I don't know. The other issue, a member of the audience had a question about the New York versus Vulo case, the NRA case that was discussed. And why was New York going after the NRA? Was it because of their views? Were they trying to suppress or censor them? Or was it because they had engaged in some kind of wrongdoing in the way they were doing their business? The answer is really it was never determined. And so it would depend who you ask. If you ask the state of New York, they would say, no, we were... we learned that they were in violation of some insurance regulations and that sort of thing. The NRA didn't have the proper insurance producer license, et cetera. They were selling some kinds of insurance that were illegal and that sort of thing. The NRA said that no, it was more politically motivated and that the insurance companies, which included Lockton, a Kansas City company, was involved in this, that they cut off business with the NRA because they feared reprisal from the New York, that it was very politically motivated and that they wouldn't have cared about these technical violations if it hadn't been the NRA, who New York politicians didn't like and regulators didn't like. So, and then when it went to the Supreme Court, it was in a legal posture where they weren't trying to decide what the facts were. They were assuming for the sake of argument that the NRA's allegations were true, just for the sake of deciding the legal issue. So in other words, they were assuming that New York officials had gone after them for political reasons. And they simply concluded that if that was true, that would be a violation of their First Amendment rights. But they weren't deciding that was true, just they were assuming for the moment that it was true. The case, I didn't really know then what happened to the rest of the case. It was sent back to the lower courts, and they never wound up resolving that issue, that factual issue, one way or the other. They decided that the New York official who was sued had qualified immunity because all this was sort of newly established law, and so you wouldn't have held that person liable anyway. So nobody ever decided what New York was really trying to do.
Oh, that's so fascinating. I hadn't known that. And the analogy that springs to my mind from the current administration is the criminal prosecution of the Southern Poverty Law Center. Again, there's a big dispute. I can't even remember what the allegations are that they were defrauding their contributors, right? And if it were actually fraud, intentional misleading of somebody to their financial detriment, it would be punishable. But the SPLC is saying, no, they don't like our policies.
All right, we're to the last question of the night. In true American Public Square fashion, the last question is usually, so what, now what? What advice do you have for anyone in the audience who wants to learn or even be an advocate after hearing our discussion?
Thank you so much for that forward-looking opportunity, which I really will circle back to what I said at the beginning, that and you understand now that this has legal significance by virtue of knowing what your First Amendment rights are and what other people's First Amendment rights are. You can actually help ensure that those rights are respected and enjoyed in reality and not just some theoretical guarantee. So I expect all of you, now that you're experts on these issues, to raise your voices to defend your free speech rights and the free speech rights of the other person whose ideas you disagree with. Because you understand that if one administration can punish those ideas, then another one will be able to punish yours. And seriously, to help spread that knowledge and information in any way that you can, in any context, whether it be, at the proverbial Thanksgiving dinner, or, a community discussion, a letter to the editor, testifying before a school board, always being aware, number one, that you have the right and other people do, but number two, it's not self-enforcing unless you do something about it. So you have to exercise your free speech rights in order to protect your free speech rights. And as I said at the beginning, all of you are well on the path to doing that. I do not at all take that for granted. By the way, I looked at some statistics to refresh my recollection. There are 6 separate rights in the First Amendment. We've alluded to all of them throughout this program, and surveys by reputable organizations, mostly at journalism schools and so forth, which will regularly survey people about their understanding or lack of understanding. Only about a third of Americans in the past 20 or so years, consistently, only about a third even know that the First Amendment protects freedom of speech. And then when you get to the other freedoms that are protected, the numbers go way, way down until the percentage who know about the right to petition the government for redress of grievances, which arguably is the most important in our democratic republic, right? Again, we the people, the opening words of the Constitution, wield sovereign power, and we do that by petitioning our government for redress of grievances. Only 11% know about that right, which is only slightly more than the 9% who know that the First Amendment protects the right to bear arms. No, that's not correct, by the way. It's the Second Amendment. Hate to be technical about it. So knowledge is power, and that's a really, really important place to start.
She knows Alan's not coming back up after this. So.
And please continue to support the wonderful institutions you're so blessed with in this community, including the great library, the great museum, American Public Square, and the other co-sponsors. And please come back on June 17th and 18th. We're having 2 programs, one at the at the Kansas First Amendment Freedom Foundation, and on the 18th, the American Public Square event about the Declaration of Independence, to continue your training as effective advocates for free speech.
Wow, I'm sorry that I'm the one that has to close out the night because I'd love to hear this conversation continue. My name is Mary McMurray. I'm the director of the Johnson County Museum, and I want to begin with a sincere thank you first to Nadine, as well as to Lacey and Professor Rostron and Yvette for all the people that helped make this event so meaningful tonight. Your insights, energy, and willingness to engage so thoughtfully is exactly what makes programs like this matter, and so let's give them a big round of applause. And I also want to pause and thank our partners who made tonight possible, American Public Square, the Johnson County Library, and the whole Johnson County Museum team, which is bigger than me. This kind of collaboration is civic life in action, different institutions coming together to create spaces for dialogue, learning, and connection. So thank you to everyone for making this happen. Okay, now I have to have fun with you all just for one quick minute. Raise your hand if you've ever been to this building before. Yay! Okay, and then raise it if you were here when it was the King Louis. Okay. This is a pretty equal percentage, and I'm glad that there are so many people that are familiar with this building. To those of you who don't know, this used to be a bowling alley, ice skating rink, and billiards hall, and a lot of people have memories here. But now it's a place where you can see live theater performances from Theater in the Park. You can take art classes. You can drop off your kids to go to summer camp. You can explore the museum, learn through play in Kidscape, a makerspace, a dance studio. You can pick up a public art passport and explore all of JCPRD's parks. And you can vote. So this is an incredible place to live, work, and play. And whether this is your first visit or your 100th, I want to say welcome. We're glad you're here. And for those of you who don't know the Johnson County Museum yet, just briefly, I'll tell you we are a nationally accredited, award-winning community history museum. And I'm really excited because today I get to share news that just came out today that hopefully you'll hear in the news soon. We are the 2026 Museum Impact Award winner from the American Alliance of Museums for our continued work on redlining. If you'd missed that special exhibit that was up in 2022, please be proud to know that the work continues, and you can learn about it at jcprd.com/redlined. At our core, the Johnson County Museum tells a story of a place, this incredible community, Johnson County, in all of its complexity. And we do it with a simple belief that understanding our history is not just about learning about the past. It's about building knowledge we need to shape a better future. And that really seems fitting to connect to tonight's conversation. As we conclude this program, I want to remind you that downstairs in the old ice skating rink, that is now the museum, is our reception hosted by American Public Square with support from our partners. Nadine will be there ready to personalize your books. The museum is open to you to explore. Do not bring your food and drink into it. You can have it on the concrete floor, but not the rest of it. And you'll also get to see our current special exhibit, Everyday Democracy, Life, Liberty, and the Pursuit of Happiness. It's a truly powerful and meaningful exhibit in these times, so much so that our friends at American Public School have put together a prize pack to incentivize you to go visit it. So after you see it, you can put your card in and try and win some prizes. And there's another incentive too for those real big history nerds there. Andrew, wave. This is Andrew Gustafson, our curator of interpretation and project leads on all of our special exhibits, Redlined and Everyday Democracy included. He will be in the gallery ready to talk to you. I hope being here is meaningful to you. I hope you will come back. This place is filled with great places and programs that bring people together to learn, to create, to disagree, to grow, and to belong. It's a community, and it gets better because of you all. So tell your friends, not just about tonight, not just about the museum, but about everything that's awesome that happens here. Say, oh, you should see this, or I didn't know this was here, because that's how our community will continue to grow. Thank you for being here tonight. Thank you for your attention, your questions, and your willingness to engage. Now, everybody give a long round of applause while I invite these two to leave first. Oh. And now, with that, I invite you to enjoy the reception, to enjoy the museum. Thank you again for being here tonight.